Good afternoon, everyone. Thank you so much for joining us this afternoon on this exciting, but I suspect a little bit complicated webinar that we're going to have. This is the first time that actually we're having a webinar discussing a specific case vis-a-vis the Labuan legal judgment, and it's a landmark case. It's the NABOS landmark case as passed by the federal court. And thank you very much for joining us. Thank you, my speakers and fellow panelists, for taking the time this afternoon. We have registered around 250 people for this, which is very encouraging. And we really wanted to go into a little bit of detail of the facts of the case. We wanted to talk a little bit to William, and William will be going through the presentation as to how he won this fantastic case. And then, of course, nothing in Labuan would be complete without a tax angle and the angle of a corporate service provider. So we have Anil here from EY. He leads everything Labuan in EY. And we have, of course, our Datuk Chee here, Datuk Chee, who is the chairman of the Association of Trust Companies. So from Anil, I guess what we can expect later on in the panel is a discussion about the tax implications of this judgment. And from Datuk Chee, what we can expect is really, the nitty-gritty details of the operations, vis-a-vis leasing structures in light of this judgment and how the market's taken to it, right? So, but before we let William do his presentation, I'd just like to highlight a couple of things. Well, actually, one fundamental thing. When we talk about Labuan, especially historically, a lot of people are under the assumption that Labuan actually, the Labuan Financial Services Authority is somehow connected to the Central Bank of Malaysia. And I'd just like to highlight that actually that is a misconception and has always been a misconception. The Labuan Financial Services Authority is a statutory body that reports directly to the Ministry of Finance and not any other statutory body within Malaysia. I think that's important to understand as the crux and the base of this whole webinar, right? So it's a statutory body created by an act of parliament. And the confusion sometimes, well, historically anyway, lay in the fact that the chairman of Labuan FSA tended to also be the governor of the Central Bank of Malaysia, right? And that's just a circumstantial situation. For all in effect, Labuan FSA is a statutory body that reports to the Minister of Finance Malaysia. So that's one thing that I really wanted to get clear from the beginning, right? And with that, and not to take up any more time, please, William, can I invite you to go through your presentation as to how the amazing work you've done to win this case. And once again, congratulations. I hear it's not been a quick win, as it were, but a momentous win nonetheless. So please, William, share with us your presentation.
Thank you, Farah, for the kind introduction. So today we will discuss the case of Nabor Drilling's Labuan Corporation against Labuan FSA. It's a recent federal court decision on the legality of the guidelines issued by Labuan FSA. So some background of the case. On 22nd of May 2012, the appellant, Nabors, a Labuan licensed entity, leased an offshore oil rig drilling platform, we'll call it Rig 503, to a Malaysian company resident in Labuan without obtaining Labuan FSA's prior approval and without payment of the requisite fees. Some 20 months later, on the 24th of January 2014, the appellant applied for the retrospective approval of the subsequent leasing transaction. However, the same was rejected by Labuan FSA. Why? This is because Nabor's action breached item 8.2 of Labuan FSA's guidelines on the establishment and operation of Labuan Leasing Business 2013, which stipulates that subsequent leasing transactions with Malaysian residents are subject to Labuan FSA's prior approval and payment of the requisite fees. So what happened next? After failing to obtain Labuan FSA's retrospective approval for the leasing of Rig 503, the appellant filed a judicial review application in the Labuan High Court, mainly on two grounds. Number one, that the guidelines have no force of law. And number two, item 8.2 of the guidelines contradicts section 7.6 of the Labuan Companies Act and is therefore ultra-virus and unlawful. The matter actually lasted 5 years in the Malaysian courts. And ultimately, it was heard and decided by the federal court in October 2020. So thus, the issues to be decided by the federal court is these two issues: whether the guidelines carry the force of law and whether item 8.2 of the guidelines contradict section 7.6 of the Labuan Companies Act. So why is it that NABOS filed this case and fought it all the way to the federal court, even though it was them that clearly breached the guidelines issued by the authority, in this case, Labuan FSA? This is because, according to NABOS, guidelines, being mere guidelines, carry no force of law. NABOS' position is this: the guidelines is not regulation, is not enactment, it's not even bylaws. Thus, it has no legal effect on them. So that's their position. In reply, we say that the guidelines was issued pursuant to the statutory powers conferred upon Labuan FSA by Parliament. In this case, it's Section 4A of the Labuan Financial Services Authority Act 996. We'll call it the 996 Act. So the guidelines is a piece of subsidiary legislation having legislative effect and the force of law. In this regard, the powers conferred upon Labuan FSA are wide, and they include power to issue guidelines to facilitate compliance with the law, powers to impose conditions, and powers to collect fees. So we'll first have a quick look at Section 4A. Section 4A is what we call the enabling provision, and it enables Labuan FSA to issue guidelines to clarify any provision of this act or the law specified in the schedule. And the law specified in the schedule covers all Labuan acts, and to facilitate compliance with the law. Because of this, we say that it gives the guidelines the force of law. And in fact, Section 4A is widely worded, and it also allows Labuan FSA to issue guidelines on any other matters relating to Labuan Financial Services. So it's really wide. And earlier, I mentioned something about subsidiary legislation. Why do I say that guidelines issued pursuant to an enabling provision is a subsidiary legislation, bearing in mind that it doesn't go through Parliament, it's not even made by the minister? This is because Section 3 of the Malaysian Interpretation Act defines subsidiary legislation as any proclamation, rule, regulation, order, notification by law, or other instrument made by or made under any act. In this case, the other instrument, we say, refers to the guidelines. And made under any act, the act here refers to 4A. And consistent with this, the guidelines falls under the definition of subsidiary legislation and have legislative effect. On top of that, given that Labuan FSA is the central regulatory, supervisory, and enforcement authority of Labuan IBFC, it also has the implied powers under Section 40 of the Malaysian Interpretation Act to make subsidiary legislation or to impose such requisite conditions, such as those imposed in the guidelines. That is why we say, pursuant to all these statutory regulations, especially Section 4A, Labuan FSA's guidelines are effectively subsidiary legislation, having legislative effect and the force of law. And the second argument raised by NABOS in courts is that the previous requirement that Labuan company must obtain the permission of Labuan FSA before it can undertake any business with a Malaysian resident previously appeared in the old section 7.1 and 7.3 of the Offshore Companies Act 1990, has been removed by Parliament in 2010 via Offshore Companies Amendment Act 2010, also known as Act A1367. So in essence, what NABOS is saying is that, look, previously, there was a requirement for me to get Labuan FSA's permission before I can deal with Malaysian resident. That requirement has been removed by Parliament in 2010. Given that that requirement has been removed by Parliament in 2010, you, Labuan FSA, cannot now reintroduce the same requirement via your guidelines. It's ultra-virus. So in reply, we say these two sections 7.1 and 7.3 of the old Offshore Companies Act concern obtaining permission to transact with Malaysian residents. On the other hand, the guidelines, in particular item 8.2, concerns the approval to carry on leasing business and the payment of leasing fees. This is a licensing requirement. So these are two different requirements. The former, under the old Offshore Companies Act, concerns permission to deal with Malaysian residents, while the latter, under the guideline, concerns leasing requirement, a licensing requirement. It concerns approval to carry on leasing business. These are two different requirements. There's no inconsistency. In fact, as far as Labuan FSA is concerned, it doesn't matter whether you're dealing with Malaysian resident or a non-resident. As long as you carry on a leasing business, be it with a Malaysian resident or non-resident, you need to get their approval. So that is how we distinguish the guidelines from section 7.1 and 3 of the old Offshore Companies Act. And what NABOS also argue is that under the new Labuan Companies Act, section 7.6, also introduced via Act A1367, as long as a Labuan company is licensed to conduct leasing business under the Labuan Financial Services and Securities Act 2010, we'll call it the 2010 Act, it does not even need to notify Labuan FSA of its Labuan business activity with Malaysian resident, let alone obtaining approval from Labuan FSA for the same. Perhaps it's easier if we look at section 7.6 itself, and it reads, a Labuan company is not required to notify the authority, i.e. Labuan FSA, of transactions between the Labuan company and the resident where A, the Labuan company carries on any licensed activity, in this case, leasing business, with a resident under the Labuan Financial Services and Securities Act 2010. So in other words, according to NABOS, now under the new Act, section 7.6, I don't even need to notify you of my leasing transactions with Malaysian residents. Surely, I would not be required to get approval for the same leasing transaction, because approval is a higher threshold or a higher requirement than mere notification. And this is why NABOS told the court that item 8.2 of the guidelines, which stipulates that subsequent leasing transaction with Malaysian residents are subject to Labuan FSA's prior approval, is ultra-virus and it's null and void. So in reply, this was what we told the court. License activities conducted in Labuan, including Labuan leasing business, are now governed by the new 2010 Act, which was also gazetted in 2010, the same time as Act A1367. Thus, Labuan company carrying on license activity with a resident under the new 2010 Act is not required to notify Labuan FSA under the Companies Act, given that Labuan company would have notified Labuan FSA of the same transactions when applying for license or approval under the new 2010 Act and or its subsidiary legislation. So what happened was this. Back in 2010, there was a major reform on the Labuan legislative framework or regime. And amongst others, there was the introduction of Act A1367 that made substantial amendments to the old Companies Act. And at the same time, there was also the introduction of this new 2010 Act, which now governs all the licensing requirements for license activities. And it also covers obligations to provide information of the license activities to Labuan FSA. So say, for example, if a Labuan company were to apply for a license under the new 2010 Act from Labuan FSA, it would also need to provide information to Labuan FSA under the same Act because it's the same licensing regime. That is why we say Section 7.6 relied on by NABOS, which removed the notification requirement from the Companies Act, was introduced to avoid duplicity in notification for the same license activity and simplify the notification requirements. In fact, it was pointed out by the federal court that, look, one license activities, you only need to notify once. And in this case, the specific act is the 2010 Act. So you notify under the 2010 Act. And that explains why Section 7.6 was introduced. And as a result, we say there are no inconsistencies between Section 7 of the Labuan Companies Act and the new 2010 Act, because all the licensing notification requirement has been taken away from the old Companies Act and parked under the new 2010 Act. And there's no inconsistency, and it was misleading for NABOS to rely on the provisions of the Companies Act as far as licensing activities is concerned. And in any event, even assuming there are inconsistency, given that the 2010 Act is a specific provisions on license activity, it trumps Section 7 of the Labuan Companies Act, which is general in nature. For this, we say that Section 7 of the Labuan Companies Act merely contains general provisions on the permitted purpose of a Labuan company, including the notification of dealings with Malaysian resident under Section 7.6. On the other hand, the 2010 Act is a specific legislation that provide for the licensing and regulation of financial services and securities in Labuan, including the Labuan leasing business. Hence, it prevails over the general provision of the Labuan Companies Act. In this regard, the 2010 Act, read together with the Labuan Financial Services and Securities Regulation 2010, provide that approval for all Labuan leasing transactions is required, be it with Malaysian resident or non-resident. Thus, item 8.2 of the guidelines, which was issued to clarify and facilitate compliance with the provisions in the 2010 Act, is intra-virus Labuan FSA's powers and functions. So after all these arguments by the parties, so what was the federal court's decisions? Firstly, the federal court held that Section 4A of the Labuan Financial Services Authority Act 1996 confers Labuan FSA with the power to issue guidelines which carry the force of law. Secondly, the federal court, after considering, amongst others, Section 40 of the Interpretation Acts, further held that Labuan FSA has the implied power to make subsidiary legislation or to impose conditions when granting a license or approval. And thirdly, the Labuan Financial Services and Securities Act 2010, being a specific legislation governing Labuan license activities, including Labuan leasing activities, prevails over the Labuan Companies Act, which is general in nature. And for this, I have a client that asked me this question: does this decision only apply to Labuan FSA's guideline on leasing business? My answer is no. It applies to all Labuan FSA's guidelines issued under the enabling provisions pursuant to Section 4A. In fact, in my view, this decision applies to all the guidelines issued by the Malaysian authorities pursuant to similar enabling provisions. So what's the key takeaway? So needless to say, it's prudent to comply with the relevant guidelines and conditions issued or imposed by Labuan FSA from time to time. Why? Why is it so? Because non-compliance may cause the Labuan company's business to fall outside the Labuan Business Activity Tax Act 990 Lebata, potentially resulting in the Labuan company having to pay taxes based on the standard corporate tax rate, as opposed to the tax rate of 3% on chargeable profit under Lebata. And last but not least, failure to comply or non-compliance may expose the Labuan company and all its officers to the risk of enforcement action by the authority. Over to you, Farah.
Thank you, William. That was, in a way, I don't know, my personal take, it was complicated but simple at the same time, if that makes any sense. Okay.
I tried my best because we spent hours in court, so not easy to simplify it into a 15-minute slice. I tried.
I think you did a very good job. And what was it? We discussed this earlier. It's five years in the making, this judgment.
Yeah, indeed.
Yeah. So I think it's quite clear. The only thing that I have a very quick question for you before I go into the tax element here with Anil and then Datuk Chee. Well, I don't understand why NABOS felt that there was such a conflict between specific and general provisions governing the jurisdiction.
Yeah, because I think it boils down to Section 7.6, because when they revamped the law in 2010, they tried to streamline the notification provision, and as a result, they introduced Section 7.6 that says if you're dealing with, say, previously you have to notify, but now under Section 7.5, if you deal with resident or non-licensed activity, you have 10 days to notify, 10 working days. But if you deal with resident on licensed activity under the 2010 Act, you don't need to notify. It's actually meant to streamline the two acts, the Labuan Companies Act and the 2010 Act. But what they did was they seized on that section and they say, look, notification is a lower threshold compared to approval. If the requirement to notify is removed, then why should I even need to ask for approval, which is a higher requirement? I think that is one of their main argument, and I think, and in fact, they believe it. They argue it. They said, look, the guidelines. See, for statutes, there's hierarchy, right? On top of it is all act, and then probably underneath it is regulations, and then below it could be guidelines. So they said your guidelines ask for approval, but Section 7.6 says don't even need to give notification. 7.6 is the main act, it's an act of parliament. Regulation is a regulation by the minister. Yours is only a guideline given by the authority. So it cannot in any way contradict an act of parliament. I think that's why they filed this action and fought it all the way to the federal court for five years.
So in a way, I guess when you put it that way, you can understand their drivers, right? As to why to do it in that sense. Anil, what does it all mean from a tax perspective? I mean, can you explain the typical tax implications that has arisen from this judgment?
Thanks, Farah. Thanks for the question. Thanks for inviting me to be on this panel. And William, I really enjoyed listening to your speech, your talk, and I'm waiting for the movie, which I'll then watch. And good afternoon to all of you out there who are listening to us today. Thank you for joining us. So perhaps, Farah, the easiest way to maybe answer your question, I know it was a simple question, but you've known me a long time. I never give simple answers. So perhaps the easiest way for me to answer your question would be through a couple of slides. And your colleagues have very kindly agreed to put up the slides for me since I'm technologically challenged. So these are the slides. So this really shows you a typical Labuan leasing structure. If you look at the top of the slide on the left, we've got a foreign company which will own an asset. That foreign company will lease the asset to a Labuan leasing company. The Labuan leasing company will in turn lease it to that entity on the right, an onshore Malaysian entity. This could be any sort of asset. It could be a plane, it could be a ship, it could be a large piece of equipment. In Nabor's case, it was the infamous Rig 503. Once we have this structure in place, the question is really what then are the tax implications? And the tax implications will start from the right of the slide. The payments start from Malaysia. So when the Malaysian entity pays the Labuan leasing entity, there's no withholding tax, so it can pay in full. In Malaysia, that Malaysian entity will not get a full deduction on the payments to Labuan because we now have rules that say that payments to Labuan may be disallowed partly from being deductible. So in the case of a lease, for every $100,000 that is paid from Malaysia to Labuan, the Malaysian entity only gets a $75,000 deduction. So 25% is disallowed. So right now, Malaysia has paid Labuan. Malaysia has disallowed part of the deduction. In Labuan, the Labuan entity needs to comply with economic substance requirements. What does that mean? That means that it needs to have a minimum number of employees in Labuan based on certain regulations which have been issued by the Minister of Finance. And each Labuan company needs to incur 100,000 ringgit every year in Labuan, about 25,000 US dollars. Once it meets those conditions, it pays a very low rate of tax, 3%. And then when the Labuan entity pays the foreign asset owner, there is no withholding tax. The foreign asset owner will just need to consider what his foreign tax implications are. And also, every single document which is executed by the Labuan leasing company here, the lease agreements, will be exempt from stamp duty. So that's the typical arrangement. I'd just like to point out that if the foreign entity on the left had leased directly to Malaysia on the right, there'd be a 10% withholding tax on the payments. So this is a bit more efficient. In fact, these are the current implications. When Nabors was actually fighting their case for those years, the Labuan tax legislation was even simpler. The Labuan tax legislation has gone through a big revamp, effective 1st January 2019, driven by OECD changes to international tax laws. And before 2019, when the Malaysian entity paid Labuan, it would get a full deduction, no disallowance of a deduction. The Labuan entity didn't need to meet any substance for tax purposes. There may be some substance required from a Labuan leasing guidelines perspective, but not for tax purposes. And the Labuan entity could elect to pay only 20,000 ringgit in tax. So forget the 3% I talked about earlier. It could pay just 20,000 ringgit, which is about 5,000 US dollars. So that is obviously a very effective, efficient structure. However, in order to enjoy a lot of these tax benefits, the authorities take the position that you must be taxed, or the Labuan entity in the middle of the screen there needs to be taxed under the Labuan tax legislation, the Labuan Business Activity Tax Act 1990, or LABATA in short. Which brings us to the case which William so eloquently spoke about earlier. So if we look at the next slide, which is extracted from the case, what the authorities said is that, look, Nabors, you didn't get the approval. And this is extracted from the High Court decision. You didn't get the approval to lease Rig 503 to Malaysia. Therefore, whatever you did, that activity shall not be deemed to be a Labuan business activity, and your income will not be taxed under the LABATA. Under the LABATA, you could have enjoyed certain tax benefits, but you cannot now tax this transaction under LABATA because, my friend, you forgot to get the approval. So if you fall out of the LABATA, what really happens? In Malaysia, if you fall outside the LABATA, you would fall back to the principal taxing legislation. So Labuan entities which carry on Labuan business activities would be taxed under the LABATA. And if you fail to get the license, the authorities take the position that you are no longer carrying on a Labuan business activity because you haven't gotten the necessary regulatory approvals to be carrying on that activity. So once you fall under the Income Tax Act, what happens? And that's really what the next slide is all about. So again, taking it from the right to the left. Earlier, when Malaysia paid Labuan, there was no withholding tax. Now, Malaysia has to make sure, the Malaysian entity has to make sure that the Labuan entity is a resident of Malaysia for tax purposes before making the decision not to withhold tax. So they have to ask the Labuan entity, did you hold directors meetings in Malaysia? Are you truly a resident for tax purposes? If not, there could potentially be a withholding tax when Malaysia pays Labuan. In Labuan, that Labuan entity, when it receives its leasing income, as William pointed out earlier, it can no longer be taxed under the Labuan Tax Act, the Labata. Instead, it now pays a 24% tax under the Income Tax Act 1967, or the ITA. And tax under the ITA is a lot more complex than tax under the Labata. Tax under the Labata, you take your audited profits, you multiply it by the percentage, 3% if you meet substance, and that's it. It's a fairly simple return. Under the ITA, you've got to go through each of your expenses, see whether they are deductible. You've got to go through your assets, see whether you can claim tax depreciation or capital allowances. So a fair bit more complicated. And when the Labuan entity pays the foreign asset owner, the authorities generally take the position that if you don't fall under the Labata, the Labuan entity can no longer enjoy the withholding tax exemption. So there could be a potential withholding tax on the payment. And that stamp duty exemption I mentioned earlier would likely go out the window as well. So a lot of not very favorable implications, which is why we can see, we can understand why they fought this case so hard, really to try and say, well, look, these guidelines don't really affect my regulatory position, therefore they don't affect my tax position, and I don't have to suffer all these tax consequences. And the last complication, if I could call it that, is that at the time this case was fought, under the Labuan Tax Act, the Labata, there were no transfer pricing provisions. And what that basically meant is that the authorities couldn't force you to prove that your related party transactions were at arm's length. They couldn't force you to provide documentation to show that your related party transactions were at arm's length. Instead, under the Income Tax Act, which NABOS has now been pushed into, there are various things to comply with, including proving that your related party transactions are on arm's length terms. So yet another onerous requirement under the Income Tax Act. So if I could summarize, the Labuan entities would generally like to be taxed under the Labuan Tax Act because then it's quite clear you're taxed at 3% if you meet substance. You get all the other exemptions which come with the status under the Labata. By not complying with the licensing requirements, the authorities take the position that you cannot fall under the Labuan Tax Act anymore. And that's why neighbors fought so hard to get back into the Tax Act, if you would, the Labuan Tax Act. And unfortunately, now that they've lost it, unless they find some other arguments to argue that they can fall back into the Labata, the authorities' position certainly would be that, look, you have to pay tax under the Income Tax Act for these transactions. In the future, if you get approval for your future transactions, no problem. For those transactions, you would be under the Labata. So perhaps, Farah, I've said a fair bit. Maybe I'll stop there, and I'm sure there'll be some questions later.
Yeah, I think the question that everybody is asking is whether they're going to get the slides. And yes, you will all get the slides soon, both William and Anil's slides. Aside from the transfer pricing issue, aside from the difference in the tax treatment, everyone knows now there are very clear ESR requirements in Labuan, which are the economic substance requirements vis-a-vis that Gazette order and all the listing of all entities and what is required in order to prove substance in Labuan. So if we took a back to the future kind of treatment to this, and we assume that during this time of NABOS, there was already the ESR, would this case even see the light of day?
Probably. And the reason being, the economic substance requirements are there to show that you can enjoy the preferential tax rates under the Labuan Tax Act. So 3% instead of 24%. And the rules say that if you don't meet the economic substance requirements, and I'll put the economic substance requirements in the slide pack as well, so everybody can see them. They say that you out of 3%, you fall into 24%, but still under the Labuan Tax Act. The whole issue here is that the courts, the regulators are saying, if you don't get the approval, forget the substance, forget the Labuan Tax Act, you're out of the Labuan Tax Act altogether. So in theory, you could have 500 people in Labuan, you could spend $1 billion in Labuan, but if you don't get the approval, you'd still not enjoy the Labuan tax benefits. So I think the short answer to your question is, Farah, yes, I think people would still take this case to court if it had happened today.
Okay. And Dr. Chin, a question for you. From the company secretary's point of view, how does this judgment actually affect your clients, right? Does it provide more clarity? Will your clients now, fall into place with regards to their submissions and their responsibility to the regulator?
Yes, as far as the decisions on the guideline is now has the force of law, I think that is very clear. That also means that the company secretary has to ensure that the clients has complied with all the requirements of the guideline issued by FSA. Otherwise, then you fall out of the labata and you'll be taxed under ITA. Like Anil has said, the implication is very severe. Okay, you have double whammy on the withholding tax, like Anil said. You cannot, whatever payment that you make is also subject to withholding tax. Whatever payment that you receive, the other party may have also to pay withholding tax if you do not have management and control of the Labuan company. Now, that means from now onwards, if you are carrying on leasing activities, you must comply with all the operational requirements of given by the FSA in accordance with the guideline. I think the important one is that the directors and officers must first be approved by the FSA, prior approval. I think the prior approval applies to new and appointment of directors. Change of shareholders also, you have to now get prior approval, as well as you have new and subsequent listings. Now, we have to be very careful on this. Now, the NABOS case also was taken to court because of, I think they have a continuation of a lease, but with different assets. And that one, you need to notify, you see. So the notification part, besides the new lease, continuation of a new lease, then you have to change of your constituent documents, as well as change of the place of business, you must notify. So the secretary have to actually ensure or notify the client, leasing client, that all this must be complied with. Otherwise, you may now fall out of the guideline and you fall out of Labata and you'll be taxed under ITA. The consequence is very severe. Then you must also, to follow the guidelines strictly, that your bank accounts must be in Labuan or Malaysia. But this may be a little bit difficult now because of opening bank account throughout Malaysia is not easy. In fact, throughout the world is also not easy. You see, so I don't know. I think we have raised this issue with FSA, and they were looking into this aspect to see whether there is any, loosening of this requirement. Maybe we can open the bank account somewhere else, maybe from your home country, because in your home country, you know the bankers well, maybe the bankers may allow you to open your bank account. But in Malaysia or in Labuan, especially in Labuan, it's very, very difficult to open a bank account. So this is, to comply this part is a little bit difficult, but we have to comply, okay? Then, like Anil has said, the budget, last year's budget has introduced some new sections into the Labata. The new section is Section 17A and Section 17B. Now, these two sections are equivalent to the domestic Section 140A and Section 140B, which is on transfer pricing, that the Director General can ignore your transaction and replace with whatever they think is possible. But under the domestic scene, the transfer pricing they have issued a guideline for transfer pricing for the domestic under ITA. They have yet to issue any guideline for the Labata. So we are waiting for that. But if your company is paying tax under ITA, the income tax department has already initiated action against you under Section 140 B and Section 140 A and B. One of my clients already received notification that you must submit your TP documentation within 14 days, no extension. Okay, so if your client has not ready the TP documentation, you're in trouble and you'll be penalized for not preparing, not having a TP document. So it's very important that from now on, but not only you have to comply with the guideline, you also have to comply with the substance requirement. Okay?
Yes.
The substance requirement is not that difficult for a leasing company because we managed to get them to loosen up the requirement of the full-time employees, which is to start with, for the first 10 company, you need 2 only, and every increment of 10, you need 1 only. Okay? And then but the other part is the 100,000 OPEX operating expenditure, but in Labuan. Okay? Now, I don't, Anil have to confirm with me, is the leasing charges is paid by the Labuan company considered as operating expenses? If it is, then it's easy to comply. If it is not, then it will be a little bit tough for each company. You know, if you have 3 or 4, or you have 5, then you need $500,000 in order to comply with the group requirement. And the other thing is you must be very careful. The Labuan company now has to ensure that in order not to subject itself to withholding tax, I think not only that you have to comply with all the substance requirement, you must also have to possibly ensure that that company management and control is exercised in Labuan in order, just in case you fall out of some of one of the things and you do not have management control, you comply with everything, but you don't have management control, then you may have problem also because you may have the chance of falling into ITA. And when you fall under ITA, the withholding tax part will come in. So that is what I want to say for now. That is to say, to advise all the trust company, ensure that your clients, okay, are in compliance fully with the guidelines, all the requirements of the guidelines. If not, then there will be a lot of severe consequences.
Yes, thank you, Datuk. And Anil, you were going to respond to that question from Datuk Chee?
Yeah, I'll respond to that question and make one other observation. So I think Datuk Chin asked, when a Labuan company makes a lease payment abroad, does that count towards its 100,000 spending? And the answer is no, because that expenditure is spent outside Labuan. It's spent to a foreign party. Having said that, your 60,000 ringgit annual leasing license fee does count. And if you do 1 or 2 subsequent transactions, you already hit 100,000. If you have an office there with a person, you would meet the 100,000. So hopefully not too difficult to meet if you meet the substance requirements. So that was to answer that question. Thank you, Datuk. And I think I make one more general observation on what Datuk has said. So we are talking about a very fundamental issue, failure to get approval for subsequent license. And that's what's kept William so busy for the last 5 years. But it also creates a very interesting precedent because, William has demonstrated that the guidelines effectively have force of law. And the subsequent approval is not the only thing in the guidelines. The guidelines also, for example, say you need to maintain books and records in Labuan. They say you must maintain transfer pricing documentation. They say your directors must be of a fit and proper purpose. If your director goes out tomorrow and robs a McDonald's, does that mean you fail the guidelines? And therefore, you lose your license because the guidelines have force of law. So as Datuk said, it's very important to go through every single line of the guidelines and make sure you comply. because it's not just a very big issue that William dealt with, which are in the guidelines. There are lots of things in there.
Yeah, and if there's anything that you will notice with regards to the Labuan legal system and the guidelines and any regulations that are issued, they are quite extensive. And in a way, you know, historically, it's been one of users tend to look at us and say, well, you're very highly regulated. But now the flip side is true. And the fact that it now carries the force of law, if anything, in my mind anyway, it creates more certainty. And I wanted to ask William, actually, you know, actually just to go back to that point, you have certainty with regards to substance in order to enjoy your taxation. Then on top of that, you now have certainty with regards to what you must adhere to, which is basically everything that is issued by Labuan IBFC and the statutes, right? That is as basic as you can get. And William, I wanted to ask you, are all statutory bodies in Malaysia, do they all have this enabling provision?
I think some have, and some may not have. Just off the cuff, I believe there's one in CMSA for SC.
Okay.
It might be section 377 that allows them to issue guidelines. And then there's also one under our Central Bank Act that allows our central bank, Bank Negara, to issue guidelines. So at the end of the day, even if there's such enabling provisions, we need to look at the wordings of the enabling provisions. Because I've come across one where they expressly says that guidelines issued herein or directive issued herein shall not be treated as subsidiary legislation. So in that case, then it has arguably no force of law. But if you have an enabling provisions that says to ensure compliance or facilitate compliance with law, then more likely than not, it carries the force of law. So I believe the one by Bank Negara, I think it definitely carries a force of law, because I remember it says something along the lines of ensuring compliance or something like that. So the moment wordings like that are there, it gives the guidelines power.
Okay, and a question for Anil. I mean, the other
we move on. I think I can get on to William's thing. I think the Central Bank Act of Malaysia is Section 95. I think yes, he has to talk about you have to comply and take a force of law. Then there's another one. Even under the Labuan Business Activity Tax Act, now you have it, Section 17A. Okay, they say the Director General may, in respect of the Act or in respect of any particular provision of this Act, issue guidelines as the Director General deems expedient or necessary to clarify the provision of this Act and to facilitate compliance of the law or any other matter relating to this Act. So now IRB can now issue guidelines.
Well, actually, yes. That was going to exactly be my question. So the other competent authority for Labuan IBFC is not necessarily just Labuan IBFC, it's the IRB as well. And so what you've said is that the two competent authorities, to be succinct, the two competent authorities in Labuan IBFC, namely Labuan IBFC and the IRB of Malaysia, i.e. the HRMC of Malaysia, they are both empowered to issue guidelines that carry the force of law that affect the jurisdiction. And so, sorry, Anil?
That's correct. And I think insofar as tax is concerned, the IRB is currently the DD authority, and on regulatory matters, it's the LFSA. And you know, putting together what William and Datuk Chin said, actually what that Section 17A says is that you know, these guidelines can be issued to clarify the provisions or facilitate compliance. And those are the exact words that William used. So, you know, it is possible that in the future IRB issuing guidelines under Section 17A would say, look at NABOS, my guidelines effectively have force of law. Interestingly, you know, the LFS, the Labata also allows the Ministry of Finance to issue regulations. So it lets IRB issue guidance, it lets Ministry of Finance issue regulations, and regulations can be issued for transfer pricing, for substance requirements, and in fact, there are very general provisions saying they can be issued for anything. And I think trying to compare the two, guidelines would probably be to facilitate compliance, to clarify, whereas the regulations can probably supplement or add to. And to give an example, the Labuan Tax Act says you need adequate number of employees, adequate spending in Labuan. It does not say what the numbers are. The regulations then prescribe the numbers. So regulations perhaps more prescriptive, guidelines a bit more guiding in nature, but we've always taken the regulations to be binding and law. And William has shown us that the guidelines also could have force of law. And just to close off on that point, when I was reading the Nabos case, and I don't know how William did this for 5 years, just reading that one case thoroughly caused me a lot of pain.
I'm sure he did a bit more than that during the 5 years, I suspect.
He created the law that went into the case, right? So reading the case, the appellant actually tried to take the position that, oh well, the LFSSA, the regulation, the law actually allows the minister to make regulations, and they tried then almost to downplay guidelines. They say, well, if the minister can make regulations, surely the guidelines may not be that important, and they tried to slip that in, but the court said no, sorry. All the provisions that William brought up, looking at the Interpretations Act, looking at the specificity of the leasing rules versus Companies Act, all those trumped basically that contention from the appellant.
Yeah. And my colleague just quickly showed me section 17A of Labata. In fact, I would say the wordings are very similar to section 4A.
Yes.
Yeah.
Correct. So all the regulators in Labuan are now empowered. So market be aware. There's a question, a very generic, interesting, generic question from Satish here about perhaps LFSA might consider amending the acts to clearly and specifically state that the guidelines issued by them are deemed subsidiary legislation. Is there really a need for that based on this judgment, do you think?
Yeah, I mean, I'm not Labuan FSA, so I can't answer.
Neither are we, but yeah, I mean.
But personally, I don't think they do not need to do so, because section 4A, or section 17A of Labata, read together with the federal court case of Nabos, clarifies it. It does have the force of law. I don't think personally they need to make any further amendments to further reflect that.
Correct, which is what I tended to think anyway.
In fact, the power to guidelines is more powerful than the regulations. The regulations will be issued by the minister. Sometimes those regulations go to the parliament. The guideline issued by this authority don't even have to go through parliament or don't have to go to the minister.
But it's for a good cause. It's for a good cause.
Yeah, I think that it's quite dangerous to think of it that way, Datuk Chee. But yeah.
I'm trying to say it's a bit dangerous if the authority must do it, in good faith.
Yes.
If it's not good faith, then we are in trouble.
Yes.
Sorry, William.
Yeah, I think the thing is this, because under the 2010 Act, the LFSSA 2010, it governs all licensing activities. And there can be only so many things you can say in one act before it becomes 1,000 pages. So the best person to come up with guidelines, like detailed guidelines, would be Labuan FSA, because they are on the ground, they regulate the industry, so they would know. So, and then also, if you were to wait for Parliament to pass it, even for very detailed guidelines, it'll take a long time. So, for efficiency and productivity, I think this is the right direction. But you're right, Datuk Chee, it has to be done in good faith, and it was done in good faith.
No, but and that's why I think it's important to understand, and that's how we started this conversation earlier about the hierarchy between FSA and the MOF, and that understanding that that it is a direct report to the MOF, and clearly there is a lot of trust there in order to empower the Director General. Sorry, William. Yes.
Yes, and just one thing to add. There's a safeguard there, because under Malaysian law, the guidelines cannot contradict the regulations. It cannot contradict the Principal Act. Say, for example, the regulations, the Labuan Financial Services and Securities Regulation, says that the fees for subsequent leasing transaction is 20,000 ringgit. So Labuan FSA cannot then issue a guideline to say, pay us 200,000 ringgit. You can't. So the moment you contradict with the minister's regulations, or even worse, the Parliament's Act, then it's ultra virus and it's null and void. So I think that's a safeguard.
Yes, absolutely. And there's a question here that's quite interesting with regards to tax, Anil. So if the ESR, which are the economic substance regulations, not met, does this mean that the entity is no longer a Labuan entity and conversely has to comply with ITA? Generally, I mean, what happens? Do you fall out of Labuan into Malaysia before you enter into this deep dark world, another dark world? Oh, how does this work?
Yeah, and then there are two questions which are maybe interrelated, or maybe three questions which are interrelated. One other question there was, what is the status of trading entity? And this is somehow related to, maybe this next question as well. So I would really classify Labuan entities generally, and of course there could be exceptions, into three buckets. And before I start on the buckets, let me just state that there are these regulations which state what substance requirements need to be met by Labuan entities. And those substance requirements are quite specific by business activity: leasing, banking, insurance, company management, fund management, etc., etc., etc. So you've got regulations with 22 types of activities. Each of those activities have their corresponding substance requirements: minimum number of people who need to be in Labuan, minimum amount of expenditure which needs to be spent in Labuan. So you could have, in my first bucket, a Labuan entity doing leasing. Oh, well, leasing is, let's not cover leasing yet. We've been thinking a lot about that. Let's say a Labuan entity carrying on insurance activities, right? So it is squarely within the substance regulation. It meets the requirements. It has the 2 or 3 people there. It has the spending there. What does that mean? This Labuan entity is now taxed at 3% under the Labuan Tax Act. So I'm on the list. I meet the substance requirements. I'm taxed at 3% for trading activity, meaning all these things are trading activities for Labuan tax purposes. And for holding activities, it's 0%. Clear. Middle bucket, I'm on the list. I'm an insurance company. I have nobody in Labuan. So I fail the substance requirements. What the law says is that I don't fall under the ITA. Initially, the intention was that I'd fall under the ITA, but the law has since changed to say that I'm still under the Labuan Act. Instead of 3% of audited profits, I pay 24% of audited profits. Now, the key question here is, do I still enjoy all the exemptions, stamp duty, withholding tax, etc.? Technically, you should, because you're still carrying on a Labuan business activity taxed under the Labata. We understand that the authorities are going to take the position or have taken the position or are taking the position for stamp duty, for example, that even if you're on the list and you're paying tax at 24% under the Labata because of failure to meet substance, you lose all the exemptions, which may not be correct. And that may be subject to further clarification, litigation in the future. So bucket 1, bucket 2. Now bucket 3. Bucket 3, I'm not on the list. I'm not doing insurance. I'm not doing banking, yada, yada, yada. I'm selling pineapples. I have an office company. A trading company. I have an office in Labuan. Oh, well, let's be more Malaysian. I have an office in Labuan selling durians, right? And I make a lot of money selling durians. I'm not on the list, but am I still carrying on a Labuan business activity? What is a Labuan business activity? It's an activity carried on in, from, or through Labuan, other than an activity which is an offense under any written law. It is not illegal yet to sell durians, to my knowledge. And this company has an office in Labuan from which it is selling these wonderful durians. So technically, this company should not have to meet any substance requirements and should still be taxed at 0% or 3% under the Labata. That is the one technical interpretation. IRB and MOF are taking the position that if you're not in bucket 1 or bucket 2, you go to the ITA. And this is now the subject of a lot of discussion, subject of a lot of potential litigation. And Datuk Chee actually has probably a lot more experience than me on this, because he's having to deal with all these questions every day. And he's speaking to authorities, he's speaking to lawyers. I think Datuk Chee probably is in between meetings with lawyers right now just to be with us here right now because of this bucket 3. And I'm not sure that Datuk Chee has something to add to that.
Yes. In fact, most of the lawyers, I think a lot of lawyers and also the practitioners interpreted that bucket 3 should not fall under ITA. Like Anil has explained clearly. If you are not in the regulations, then if you are carrying a business which is under the definitions of Labuan trading or Labuan non-trading activities, although not in the substance regulation, you should not, that means you don't have to comply. If I'm not in the regulations, but I am carrying on an activity which is defined under the Labuan Business Activity Tax Act, then I don't have to comply with the substance requirement, but I'm still taxed under Labata. But Income Tax Department has the different idea, I think, in order to collect more money. They said, no. If you are not here, if you are not in the subsidiary regulations, then you fall under ITA. And because of that, I think they even on the 5th of February, they even give us a letter. Previously, they have what they call other trading activities, Code 23. Okay, and if you carry on other trading activities, you comply with the subsidiary requirement, you'll be taxed under Bata at 3%. Okay. Then on 2nd of February, they say, no. This other trading activity, Code 23, is not inside the regulation that has been amended. Okay, subsidiary regulation has been amended, and therefore you do not pay tax under Bata. Now, for 2019 and 2020, you have to resubmit your tax under ITA. And this is retrospective effectively from 1st January 2019. Now, I don't know why law has this type of effect one, going backward or not going forward. If it's going forward, then I think we are okay lah, you let go for the 2 years, and if you move forward, you tax under ITA, maybe there's not so much of resistance. But now it's going back. I already submitted, and then you ask me to take back my submission, resubmit again. And because of that, I think there are now litigation going on. I think this week and last week, I think there was a case, I think 71 of the company has already initiated leave applications with the High Court. And they also applied for ex parte, I think, application. But I think the judge says that I want the IRB to come in. I don't allow. That's why the IRB came in, and now they are given up to 24th of April, I think, for the judge to make a decision whether to accept the leave application, and also there is a temporary stay at the moment, from the day that I think last week, I think up to the 24th of April, there's a temporary stay. So the people don't have to pay their tax first, so they submit their tax first.
So there's a lot more to look forward to, I guess, from the legal point of view vis-a-vis Labuan.
Yeah, so William might want to retrain as a tax lawyer.
But actually, I've got a question for William. Yeah, sorry, Datuk.
More people coming in to go to the court to make a decision. I think this 71 is not related to the ALTC one. They individually, they will approach another lawyer to do. The LTC has approached another lawyer to take up the case. And that one, we don't know, maybe hundreds of them will be in this, but it's in the process of being prepared and to go to the court.
Well, I guess that will be the subject of a next webinar when it all becomes clear. But I wanted to ask a very important question to William, actually. I mean, we're talking about the powers of the regulator. What about the potential enforcement action? What is the potential enforcement action that can be taken by Labuan FSA?
Yeah, ultimately it varies on the severity of the breach. So, and the enforcement action can range from, say, administrative penalty of 10,000 ringgit, which is about $2,500, to being charged in court. And for example, if it was done fraudulently or dishonestly, then you might be charged in court. And if you're found guilty, the fine for a company is 3,000 ringgit. And then the fine for individual is 1,000 ringgit. So that's on the other end of the scale.
And maybe administrative penalty also. The FSA also can impose administrative penalty on a daily basis.
Correct.
Yeah. I think that's about 4,000 or 5,000 per day, right, Datuk Chee?
Yes.
Yes.
Yeah.
Yes.
Yeah, and which can adds up and it can hurt.
Well, it adds up very quickly, I can assure you.
And every day there is conservation you have to pay.
Yeah, exactly.
Yeah, I just wanted, because we're a bit over time, but we still have close to 170 people watching. And I wanted to ask this question by one of the, I wanted to just follow one of these questions. The regulations state the type of business activity, ESR based on business activity, Anil. What happens when you're not licensed? So i.e. Private fund. What happens, what is your tax position when you're not licensed?
Yeah, I think the first question is whether you are required by law to be licensed. And then I'll explain why. So coming back to what I said a few minutes ago, what is a Labuan business activity? It is a Labuan trading or non-trading activity carried on in, from, or through Labuan, excluding any activity which is an offense under any written law. And these last few words may apply here, excluding any activity which is an offense under written law. If I'm a fund management company or a leasing company, and the law requires me to be licensed, and I do not get licensed, then I guess from a legal perspective, does that mean it's an offense? If LOFSA can now compound me, surely it is an offense not to be licensed. And if I'm doing something illegal, something which is an offense under written law, then you could fall under the Income Tax Act instead of the Lebata. Because yes, I may have people there, I may have an office there, but if I'm not licensed to do it, it's an offense, and therefore I fall out of the Lebata, potentially. We've not seen this explored yet because this new definition of a Labuan business activity came in from 1st January 2019. That's certainly how I would interpret it.
Okay. And there's another interesting question about contradiction in guidelines, which in a way is theoretical, because obviously the two competent authorities, i.e. Labuan IBFC and IRB, are competent authorities in very distinct areas. But in the event that there is a contradiction between guidelines between the two competent authorities, which should we follow?
Yeah, I think firstly, the chances of there being inconsistency in the two guidelines, I think is slim, because as far as Labuan FSA is concerned, every time they issue a guidelines, they will consult the various stakeholders, and IRB being one of them. But in any event, even assuming there's contradiction, we go back to the federal court case that says the specific legislation, in this case, the specific guidelines, trumped the general one. Say, for example, if the guidelines issued by IRB governs tax, then, and if we are looking into a tax matter, then I believe the IRB guideline on tax or specific on tax would prevail over the other guidelines. That's how I would interpret it based on the federal court decision.
Yeah, I'd agree with that. I'd also add that I think the issue is not so much contradiction. I agree with William. I don't think we've seen contradiction in writing anyway between the two authorities. What we do have is a lot of guidance from LOFSA and maybe no guidance from IRB on certain things. So I think LOFSA is then trying to maybe help the investors a little bit, help businesses a little bit to say, well, we know you need clarity. Let us go and do something for you. We'll consult the Labuan Investment Committee, we'll consult the IRB, the MOF. Let's try and give you some guidance. And that guidance, because it's issued by LOFSA, is helpful, it is persuasive, but it is not necessarily binding from a tax perspective, because as William said, LOFSA is not the authority to issue tax guidance. And this, I suppose, we maybe need a bit more clarity on that going forward. Maybe LOFSA needs some powers, maybe with consultation with IRB to issue certain things, because really coming back to something I think Datuk, Chee and William said earlier, speed is what businesses need, which is why there are these provisions, and I think William pointed this out, there's provisions to allow LOFSA to issue guidelines for certain things. There are provisions for IRB to issue guidelines for certain things. We can't wait a year, 2 years, 3 years for something to go through Parliament. And okay, guidelines may not be right, they may not be perfect, but we can put out the guidelines to cover maybe 80% of what people need, and we can improve the guidelines along the way. I think there's no harm in improving guidelines, as long as we don't go back on the guidelines and retrospectively try and impose something on people. I think it's fair. We may have a guideline which covers 8 out of 10 people. Next year, somebody else comes in, we can improve the guidelines. But speed is what businesses need. And that's why I think LOFSA has been very helpful in issuing things. But people just have to be quite careful that it is good, it is helpful, but it may not necessarily be binding insofar as it relates to tax.
Absolutely. And, we've had suggestions come in to us, and also the regulator for a fact, like, with some of the larger Labuan users, to recommend a joint committee between the two competent authorities to ensure that there's clarity from get-go. And we are out of time. We've been out of time for 10 minutes now, but we can always make time. And I just wanted to ask all three of my panelists one very important question. Criticism about Labuan IBFC since our tax changes has been, rolling our way no end. But with change, there is always confusion. Net, clarity will come through. So do you or do you not feel that with these changes, in order to meet the international multilateral requirements, vis-a-vis tax and also business operations, do you think that Labuan IBFC will eventually at some point in the very near future reach a point that there is enough clarity for business, which personally I feel there is, but I'm maybe a bit biased for business? Do you think that we will find some kind of middle ground moving forward with regards to taxation in Labuan IBFC? Any one of the panelists? Oh, just to be clear, this is a question that none of the panelists knew I was going to ask. So, anyone, please, any comments at all before we end?
I'll kick it off, or maybe Datuk Chee wanted to kick it off. I'm not sure.
You first.
Okay. So I'll kick it off, and then maybe my fellow panelists can add. So as you said, with change comes confusion, and really what we tried to do in Labuan, I think, is we tried to be a gold standard. So obviously the OECD said everybody needs adequate substance, and all we put in to Labuan was really based on OECD recommendations. And all low tax jurisdictions, the BVI, Caymans, have actually complied. And in fact, countries that have not complied have been put on EU blacklists, and we're very fortunate we're not on a blacklist. So I think the fact that we put in guidelines, regulations, rules in itself is not bad. I think then the clarity is what is important. And I think the intention was very good. We had this thing called the Labuan Investment Committee made out of LOFSA, IRB, MOF, who were meant to meet and come to decisions regarding implementation considerations. I think that needs to be strengthened. So one big issue which Datuk Chee mentioned is now going to court on these activities which are not covered. To me, that should have probably been dealt with at the LIC level, rather than letting it escalate to court, so that there is a bit more clarity. There's perhaps less resources spent on time figuring out what the tax rules mean, and people can then go ahead with business. So I think, long story short, I think the rules internationally compliant, and they need to be. We are not on any blacklist, which is great. Where we could have improved and we should improve is really in terms of clarity and implementation. The infrastructure is already there. The LIC is already there. I think the LIC just needs to be perhaps delegated more powers, maybe meet more often, maybe provide guidelines more often, and stick to those guidelines. And I think we will be good. I think that needs to happen sooner rather than later, because obviously businesses want clarity sooner rather than later. And I think now is really the time when, post-COVID, a lot of people are looking into their structures, looking into their business. It's a good time to give that clarity so people can still see that Labuan is a viable place to be.
Okay, may I?
Yes.
The law as of now, I think is about 80% certain, okay? The uncertain part is on the trading. So those that are certain, like the subsidiary requirement, they spell out very clearly, well, these are the activities that you must comply with substance. If you are coming in to carry on those activity at the moment that are listed in substance requirement, I think you should not have any problem. You know where you are, you know where you stand before you come in, okay? And people may look at it and say, okay, I can comply it, and I can get 3% or nil tax if I comply. I think this is still very attractive. What is left is the part on the trading activities, the general trading activities and other trading activities and all those services, consultancy, management, those are all not included. So those things, if income tax is not going to clarify or they have not confirmed that those activities will be under ITA, that's why the podcast come in. So now we have to wait. Okay, what happened? Maybe 5 years,
Oh,
for this to decide and go to I think it will go to federal court. You know, all you know. Knowing IRB stance is very, they're very adamant about their stance. We will go to federal court 5 years, but other than that, if you're not carrying out trading activities, then I think it's quite certain. However, all the amendments with the law, I think Labuan is getting less attractive, put it that way. Okay, some of the activities may even be worse off than the domestic scene. Sometimes you may be even better taxed under ITA. If your business has foreign source income, having property in London and you receive rental income, you might as well, pay under ITA rather than Labata, where you still need substance requirement, you still need, OPEX and so on. If you choose to pay under ITA, then you don't need that, right? But anyway, those issues, if you have a property in London, I think you will be out of scope. Because the regulation of Labuan trading activity says that your property must be in Labuan. If you're not in Labuan, then you are not, right? I don't know. Anil may agree with you. There's a question, the last question, talk about this.
Yeah.
But sometimes it's better to be taxed under ITA rather than under Labata. But you must choose. You must know the situation. When you come in, if you know that where you are, I think it's still very attractive. Okay.
William, your last thoughts?
Yeah, I think Datuk Chee and Anil have covered it all, but I just wish to add that from my experience dealing with Labuan FSA, they're quite proactive. And if they see a problem, they will act very quickly to engage the different stakeholders and to resolve it. So I have a feeling that this may be resolved sooner rather than later.
Well, we're hoping so.
The process of being resolved, actually. The process of being resolved, but we don't know when.
Yeah, well, we're hoping so. And I think, gentlemen, I think what's happening here is like with all change, there is a recalibration of focus areas, policy. There is probably a bigger thought process happening behind the scenes as to what the government and the regulator wants Labuan to become. We're going to launch our annual report or our market report the last 24th, I believe, or 22nd, 21st to 24th of April. And yes, there has been a reduction in box standard trading companies or box standard companies, but our licenses have grown tremendously. So, it could be, from the outside, it does look very confusing. But there might be higher wisdom in all this, and that's probably the best way of ending our discussion here today. And I'd like to thank all our panelists, everyone who stayed with us. We're 20 minutes over time. Thank you so much. There are some questions here that have not been answered. We will get back to you. The slides will be made available. I think the team is getting ready to hoist up the feedback forms. Please let us know what you think. Would you like us to continue to have discussions like this going forward as well? And have a good evening. Thank you very much, everyone. We hope to see you again. Take care.
Thank you.
Bye.
Thank you.
Take care.
Bye.